what happens when the stay is lifted in response to a motion for relief in my bankruptcy? Often in a Chapter 13 bankruptcy, clients continue to make, for example, their mortgage payments during the case. If they fall behind on those payments and a motion for relief is filed by the mortgage lender, that lender is asking for permission to foreclose. The client might be a few months behind in their payments on the mortgage. So what we first try to do is work out some arrangement, if the client wants to keep the house, to catch up those missed payments so they can keep the stay in place, have the motion for relief resolved that way so the client catches up the payments over time and keeps their house. Now sometimes things just become too burdensome and too expensive and the client eventually doesn't make those payments, or for whatever reason the court says, no, enough is enough, we're going to lift the stay and permit the lender to foreclose. Well, that doesn't mean the house immediately disappears or is foreclosed upon. It just means that the protections that were otherwise there from the bankruptcy court have been lifted. That's what it means when they say they want a motion for relief or a motion to lift the stay. Those protections are gone. The creditor, normally in this case or this example, the mortgage lender, is then able to proceed with foreclosure options. Again, you may still have the chance to work things out with that lender outside of the bankruptcy. I always encourage clients to do that if they want to keep their homes, but ultimately the bankruptcy will not offer any protection to the client at that point once the stay has been lifted.